Hello, everyone. It's about time for us to start talking about some things that I think will still be roadblocks for Team Trevizo, no matter what evidence comes back when the Supreme Court gives us a decision.
Honestly didn't know she was pregnant. I didn't know.
Indeed, the placenta was never found.
And even after they told her that she tested positive for the pregnancy, she was telling her mom, "No, I haven't had sex, Mom. I haven't had any sex. I haven't had any sex." That was before she went to the bathroom.
And this is a 20-year-old.
She's 19.
19.
Yeah.
Now, this roadblock, this serious issue for the defense, in my opinion, in the Alexee Trevizo case, is one we've barely ever glossed over here. And that is because there's been a serious battle of evidence that has case law and has, the potential to sway precedent in the state of New Mexico. And in my opinion, detrimentally impact the safety of the children of New Mexico. And for that, we have followed this case legally extremely close. We have read every single document. We have followed every step of the way because the legal arguments and everything that has happened in this case to have it make its way to the Supreme Court has been huge and touches on multiple points of precedent for Miranda, for waiver of privilege when it comes to issues of children. All of these things are things we have to be thinking about getting potentially reversed or limited in the future based on the arguments that the defense has made in the Alexee Trevizo case. And with that in mind, we've not wanted to fall back on a fail-safe or pull the parachute cord too early and discuss 11504D3. In this case, we have exclusively been arguing over 11504D4 down there at the bottom, required reports. As everyone knows, there are people who have to report certain things like child abuse. And in this case, that is what the defense has been arguing about this whole time for the doctor. And they believe that the doctor should not have been able to give as much information as they did to assist in this investigation. That's essentially the issue that has been boiled down as succinctly as I can put it. Now, no matter what happens in the Supreme Court, and of course we are always hoping for the evidence to be returned to the state because of the long-term impacts to justice for the children of New Mexico, we can look specifically to the outcome of this trial potentially and the evidence that can be, used in trial based on what the defense does. And that's because should the New Mexico Supreme Court not return any of the medical evidence back to the state, let's say they uphold the, district judge ruling and suppress all of the medical information, you have to stop and ask yourself, based on 11504D3, what defense would Team Trevizo have left? Because even if all the balls were in their court, they held all the cards when it came to the medical evidence, should Team Trevizo decide to use any medical evidence as a defense in their criminal case, it reopens the door to all of the medical evidence once again, because they cannot pick and choose what medical evidence they allow in based on 11504D3. This would be a real thorn in the side of Team Trevizo based on what we can assess as the things that have been, given to us as the public from the defense in this case, that potentially they plan to use a lot of medical information to defend Alexee, such as the hospital's actions that night, such as the morphine that made its way to baby Alex's system, such as letting Alexee go to the bathroom by herself. These are all things that the defense may try to use in the criminal case. Whether they, help with reasonable doubt remains to be seen. But take all of that away and say that the state is left with only the evidence that hasn't been suppressed. The hospital hallway footage of Alexee going into and out of the bathroom, and the autopsy. Even with that, many people would say that that is an extremely strong case to take to trial, even on murder one. And the defense will have their hands tied based on the defense they choose to put forward. Because what can they really do without bringing up anything medical to defend Alexee Trevizo? If you can think of a proper defense in this case that does not include any medical information, I encourage you to share it, because at this point, I cannot think of a proper defense for Team Trevizo, one that doesn't rely on blaming the hospital or any medical issues or actions that night. Because again, that would kick the door wide open for the state to get to use their medical evidence to rebut the defense's case. And so if you can think of a completely non-medical defense, something that could bring reasonable doubt as to a murder charge with the autopsy and the hallway footage as the evidence, with no other medical information being entered on behalf of the defense, then I would genuinely love to hear it, because you may be a criminal defense expert if you can come up with a defense for this. And these are just my opinions, but I have thought long and hard about how you defend this case without obviously using the morphine, blaming the hospital, trying to victimize Alexee in some way and show her as weak and meek to the jury. And for Alexee, a lot of time has passed, and who knows what she truly will, look like or appear to be in front of the jury. And of course, they'll be remembering her as a 19-year-old, but I think it'll be a lot harder for a jury to disconnect a 19-year-old from, a 21, 22-year-old, however old she'll be by the time she gets to trial. Like, they may see her as a young woman who should have known better because her age isn't below 18, because she isn't someone that they can really excuse those actions for in her mind. And so this length of time is also potentially an issue for Team Trevizo, because she's only been able to get older and look more mature as time goes on. And we don't have a lot of clear and convincing photos or video of Alexee that night that would, make her look even more frail or sympathetic, unless the defense wants to use it themselves. And here's the kicker: the most sympathetic part of all of the evidence is Alexee Trevizo in the bed, trying to say the same thing she's been saying throughout this entire trial, in my opinion, which is nothing was breathing, nothing was crying. With that, if the defense wants to use that information or use that sympathetic moment of Alexee in the hospital bed, it would be countered based on 11504 D3 by the state being able to use Rosa's statement, which was, "I just asked you to tell me the truth," which implies, and will more likely than not, in my opinion, sear into the jury's mind as Alexee potentially being asked before she even went to the bathroom, which also undercuts a huge, piece of the defense that they are going to try and build in this case, in my opinion, and something that has caught fire. Depending on how true it is or not, is going to have to be taken up in court with the inconsistent statements and some of the issues that we have, floating around if Alexee Trevizo was indeed told if she was pregnant or not. But the narrative of not telling Alexee Trevizo she was pregnant would be something the defense would try and hone in on, because it would hopefully negate the knowledge of pregnancy, even though it won't fully negate the act of premeditation tied to murder one, because it only takes a split second. So in my opinion, this really cuts off an avenue for Team Trevizo. There's just no way around it from how I see it, because the one thing I've seen trip people up is the argument over whether Alexee Trevizo was told that she was pregnant or not. Even though, like I said, when it comes down to premeditation, that is kind of just a canary in the coal mine type of argument. It's not what actually would apply to the knowledge, and it could be applied to the circumstances surrounding what we know about the death of baby Alex. They can infer the intent based on the circumstances he was left. And maybe it's just my opinion, but a defense of, believe me, the baby didn't look alive to me, they may have been alive, but not to me, is probably one that might be a little bit too far-fetched and a little too convenient for a jury. But we have to allow the defendant to have their alibi, to have their statement. And with that, when we're discussing 11504 D3, it reminded me of something super closely related that Justice Bacon said to the defense at oral argument.
Can I ask a really different question that's just been weighing on me? So assume the court agrees with you on either Miranda or privilege, the case goes to trial. You've indicated today that the basis of the defense will be stillbirth. Aren't her statements supportive of her own defense that you're working so hard to exclude here?
Great question by Justice Bacon at oral arguments. And it leaves us all to wonder, what's really going on for the defense, for Team Trevizo, when basically everything that they're seeking to stop and suppress are the things that they themselves will need at trial. And should they try to use them at trial, it would reopen the door for the other side to have all their evidence back anyways. And with that knowledge, and with the knowledge that the justices sat on a Supreme Court must have, what do you think we're going to see in the decision once it comes?
Any day now. Rain, shine, was fate denied by state time. Your cage rhymes contain rage behind gang signs. Remember chicken spitting game at you? I'm praying with a flow when you